I'm ready to take questions.
There is one Mr. Nitya Kumar, sir.
Okay.
Uh, he is an assistant professor from Keshav Memorial Law College. He asks why softwares can only be copyrighted in India and not patents. On the other hand, in US we can obtain patents for software.
Okay. So good question. See, sir, basically, copyright even in the US is not patentable. I think there is computer-related inventions are patentable, but copyright per se, even in the US, doesn't get a patent. It is coming under a literary work in our Copyright Act. So, and even in Section 3 of the Patents Act, which says that programming language, software language, algorithms, flowcharts, and all are not patentable. But if any software is embedded in a hardware with a technical effect, okay, showing a improved technology effect or improved demonstration of impact. Suppose I have a programming language through which my billing process is faster, or I have developed a programming language where my printouts are coming faster, then in a minute I am getting 10 prints instead of 5 prints. So that technology is protected where under a drafting style of a method and a system and all, but not software per se world over is not protected. Mere algorithms, mere software language, open source language, or whatever it is you're using, the open source or the the language which you're using, it is not patentable. Yes, it can go into a patent provided the software is embedded in the hardware and you prepare your specifications in such format which will actually fill the which will suit the statute of the land and drafting process. So then that will give you a subject to the patent office again. It doesn't mean that even in India, if you see, I would say if you go to computer related inventions, around 2000 patents are granted on software IT. So it doesn't mean that you're not granting. It is how you draft, how you present it to the patent office, and what technical effect it is showing with hardware, and what innovation inventive step is there.
He says there was a discussion in the recent past about not to allow COVID vaccines for patent in view of the demand for vaccines. What is the present state of COVID vaccines? Are they patented now?
Yeah. So COVID vaccines are patented. Okay, the question is, when there is a national emergency or a health emergency, so there is a provision that the government comes into the picture, and based on the Doha Declaration, which says that any health emergency or any kind of non where developing countries which do not have access to technology can be given at a zero price, provided to save the mankind or the thing. The same thing happened where these patents were given for licensing at a very low cost. So that's the reason, if you see, there are now 14 vaccines world over which have been produced by XYZ firms. So patents can be granted to the vaccines, but it also can be licensed at a price which is workable, so that the common man or the society gets it at large. So, but definitely, if they are not giving or not willing to bring that technology, bring that at a particular price, or not manufacture it in that jurisdiction, then there is a provision that the government comes in and gives a compulsory license where there they can mass produce. There you then the patent rights goes in. So the government that can intervene anytime and then take it forward. So yes, it is a question, but you have spent so much of money on dollars or billions of dollars, like Bharat Biotech and AstraZeneca or Serum Institute. So how Serum Institute is manufacturing, it doesn't own the technology. It doesn't own any kind of IPs on the vaccine. So they have the teeth and nail for manufacturing. So they have researched, they have tied up with Oxford, AstraZeneca and Oxford. The vaccine has come to India, and we have got it under the licensing agreement at whatever price they are doing it, and then they are selling it and going ahead. So that's the reason there's a cap on the by the government cost, rather than you. So the idea is, don't do profiteering from intellectual property rights. You can do profit, but don't start doing profiteering, which means that you start milking whatever it is after 20 years or 5 years. If you're ROI is done with 2x, 3x, venture into a new technology and then give it for free. That is what people want to, rather than sticking onto it and making money after generations after generations and profiteering. So IP is not for profiteering, but yes, there is a players like multinationals have done it, evergreening of patents, don't want people to come in. So that's the stand. But yes, vaccines are, they have been granted patents. New technologies, new vaccines, oral vaccines, nasal vaccines, all these are patented, and nobody can do it without any permission. The moment you start doing, you will be sued. So even for that matter, even I think the brand name was under the under a trademark violation. The Covishield, or I forgot. I think Covaxin or Covishield. Yes, Covishield was a company's name which was selling a product of nasal drop or something. So they filed a suit against Serum Institute on trademark infringement for Covishield violation after the launch of Covishield happened. So then they have an outer court settlement saying that okay, this is not done. So that's how it is. It's not that anybody can be looked into. So the more you use a trademark and you have that thing, it goes in.
Next question by one Mr. Ritvik. Respected sir, do the personality rights of a person under IPR prevail in India as well?
Yes, see, there personality rights will prevail for everybody. It is generally, it comes under contracts, like it will be your IPC thing. It's like defamation. So, or there was a case in the High Court for Rajnikant's movie. I forgot the name of Maihu Rajnikant. Yes, the movie had a Tamil director was making a movie, Hindi director, Bollywood, as the name had Maihu Rajnikant. So he had taken the rights from Rajnikant to do the movie, and the NOC was given. But after a while, when the movie was being carried out or it was done, and then just before the release, I think there was this some of the scenes or some of the storyline showed Rajnikant in a dark, shady character, where it was not going well with the personality of Rajnikant or the repute which he commands in the society. So then he lodged a complaint in the High Court, Madras High Court, and this was, I think, fought by, I think, the law firm Brinda Mohan. I think, yes, Anand Mohan Associates was their lawyer who fought it for Rajnikant. So the court held that yes, while there is no IP per se, that you cannot use the name Rajnikant is a name. Definitely, you can use Maihu Rajnikant, or you can, because Rajnikant can be names of multiple people, not only the actor. But now you can't use SRK for that matter, because SRK has become a brand name. He has filed a trademark for it. So anything, so same thing if Rajnikant had filed anything, so but he had given permission, but as a defamation, his personality rights have been violated because of not being told what is being shown, or he's nothing. So he was the court gave an immediate injunction, and permanent injunction was granted. The movie never released, and it was brought down. Probably it didn't went into the theater just before the release. This case came into the court, and so definitely, if you do such kinds of notorious things with personalities, for that matter, even while personalities, because they have a teeth and nail, your PR manager will come into action. You will get a huge notice of crores, so you will succumb to the pressure. But for a commoners like us, if somebody copies us, nobody will copy us. First of all, what if they copy also or try to emulate us? Then of course it is a violation of your personality and rights and defaming you. If somebody is using your name in a bad repute, then you can't. But in India, we don't have a act or a statute for personality rights per se. But yes, you can actually bring this to the court as a defamation or violation of your repute or brand under the IPC.
Next question by Mr. Rajaswamy Aldandi. Sir, if 75% is mapped with already existed technology, but 25% is new and innovative technologies, and in design level approach, can we implement IP rights over 25% of technology and design separately? If the high level design done with new emerging technologies, only whether it is eligible for IP rights?
Yes, it is eligible, provided that is very, very important that you show the patent office there is an inventive step. So at least one element in combination has to be new, novel, and has to be inventive. If you can show that into the patent office, it is not about your percentage of 25% or 10%. Even you have a 10 patents and 10 problems. For the 11th problem which you have identified, you are giving a 11th solution. So if you have that 11th solution, you cannot use all the 5 or 6 patents in combination and come out and say this is new. Okay, using a thing, but though it is new, it is not inventive. So one element or one aspect of something in that process or product has to be novel, which is not there existing anywhere in the prior art, either in literature, business, or in patents. Then only it will qualify for a patentability subject matter, subject to the claims drafting, and then how the claims are wordings are there, or if any documents are not cited, that also case to case. But of course, it is nothing to do with percentage. Even if 10% is new, novel, not disclosed anywhere, and it is giving proof of concept with inventive step, it is well and much in demand. You can get a patent in India also. If we were not having novelty or inventive step, but if you can show an economic significance, or doing a process which will reduce your time lines or cost in extracting something from through a process, that also is patentable. So the Patent Act clearly says in the specifications that even if it is not novel or having inventive step, if it gives something which is economically significant to the society, and you can prove that in your workings, you are still eligible to get a patent for it.
Next question by Dr. V. Sundaresan. How does IPR law help the IP owners? So
okay, so IPR law basically, as I told you, it is you can use it to your advantage. You can use it as a scientific tool if you're an academician. You can use it as a business tool if you're a businessman. You can use it as a legal tool if you're if you are trying to bring in new products, make money and all that. And you can use it as a an asset or a tangible thing if you're looking at generating products. So it is how you use it. So it depends on the company, the strategy. Suppose for an academician, IP rights might be only for fame, only for getting listed in the inventors column. For a businessman, it will be to get his valuation done, so that the valuation cost is more. He can actually look at what are the sales happened, what are the projection happening for the next 10 years from his brands. So his valuation increases. For a trademark patent design, it gives a revenue model. It is a legal tool for people who want to take action and enforce. So it is as per the case to case it is used. But basically, I would not say, one thing you should remember is it can be an offensive as well as a defensive way. If you want to go offensive, is that you need to file a lot of IPs, take action against your things. Defensive is just don't interfere into any other patent, know your IP rights, know others' IP rights, copy to the extent where you can come out easily, where patents are not there in that country, you can practice those inventions. So that is defensive IP. That's how you use.
Next question, can I apply, one by Chandrasekhar Patnaik, can I apply for a management model invented by me for a patent?
Management model per se will not get a patent, sir. But if you have a system or a process, which will actually give some kind of technology through an app where you are managing the management college app, then it can get a patent. But this management model will come under a copyright model, which is like you're doing of business, or keep it as a trade secret. Why do you want to publish it and get it copied? Some managements, like this, if you say, elections are coming, I would just want to make it an analogy. Amit Shah is called the Chanakya of politics. So you never know what is the next step. So trade secrets are big, very, very, IP is very, very rampant in politics. Trade secrets. If they want to publish a book on how to win elections, I think nobody will read it, or they will not give the exact mantra of how to win. If you have a management model, look into, make it as a module, title it as a some kind of a new flashy title, and then publish a book on it, and then people are free to take your copyright, do publication, learn from it, share it or use it. But patent per se, it needs a technology intervention, It needs a improvement, inventive step. If you can convert that into something, an app or an IoT related thing, or a something which is working in a tangible form in a device, then I think you can get a patent for it too. But models, business method patents, way of doing business, ideas, and all per se will not qualify for patents.
Next question by Mr. Panir Selvam. Is there any
Okay.
interlink between Copyright, Trademark, and Design Act?
Yeah, good question. See, in copyright, basically is for your literature work. Okay, anything which is artistic, which is music, literary things. That design doesn't come under it, because but you can get a copyright. I'll give you an interesting case study on a Coca-Cola bottle. Coca-Cola, the bottle which has come, the new one, which is just a bottle of Coke, which is shaped, which is very unique, 200 ml bottle. So initially they wanted to file a copyright for it, saying that it will serve them the purpose for 65 years, 60 years, because copyright is valid till 60 years from the death of the author from the publication. So then the patent office said that this is an article, so it cannot be copyrighted, and you are producing more than 50 copies of it. So if you are producing more than 50 copies, it cannot get a copyright of it. If it's an artistic bottle for only as a souvenir and you're producing less than 50 copies of it, then it could get a copyright. But you will be producing millions of bottles. It's an industrial product, so you will not get a copyright for that. Then what did Coke do? It went for a design application. The design application of the Coke bottle was perfect. But again, the strategy is that if Coke will file a design, it's valid only for 10 years. And then the copyright on the design is for 5 years. So 15 years of protection. But whereas copyright was 60 years of protection. So this is the link, copyright, design. Coke went to file a trademark for the bottle, the shape of the bottle, because trademark says anything which is the shape of the goods, symbol, mark, logo, color, also are subject to trademark. So the bottle of that Coke is now a trademark of Coca-Cola. So what that means, it's perpetual. Till Coke wants to come out with a new bottle, it can use that bottle and nobody can copy that bottle. So this is the strategy which you should use. So after going through a copyright, going through a design, they found trademark was the best possible protection for their bottle shape, because it became a trademark in itself, the bottle of Coke which is used. So that's the interlink. And trademark will help you to identify the producer. Design will help you to give you a feel of that particular aspect, whereas copyright will give you a link with the author, and it gives you who is the author, who is the publisher, and all that. So these are all different forms used with, and mind it, they have all very, very good civil and criminal remedies. Especially copyright and trademarks have huge criminal remedies also. And designs, unfortunately, you can take a civil action but not a criminal action in India. But yes, patents also you can take a civil action by true damages. But designs and trademarks and copyrights have severe criminal remedies also in the act. Thank you.
Next question by one CS Ravi Raghavan Kotla. Sir, if software embodied in a hardware which is subject matter of patent having prior art, when the same software is alone applied for copyright, will such copyright be granted? Because the
Yeah.
expression of idea remains same, but protection is accorded in the form of patent.
See, the simple thing is that for copyright is granted for anything which is original. It doesn't have to be novel. If it is original work of yours, whether it is, if the language of the source code and the object code, if you are giving it to the copyright office and your language is the same, used and your coding language which you are using is the same, then you will not get a copyright for it. Of course, because it is already filed or somebody else has taken it. But if it is a new language or a new coding which we have done, definitely if the technology is embedded in some other devices also, if the code is new and the code is having a originality and you are the author of it, you can go for a copyright protection.
Next question we have from Mr. Panir Selvam. Sir, how Design Act is attracted with respect to food items, whether it is applicable to food items? The Design
Yeah,
Act.
food items, yes, Design Act is, but nobody generally wants to file, Because see, how will you file for a biscuits? You have so many designs of biscuits. When you were children, Chand biscuits were there, Star biscuits are there. If you want to file them, you can file. There's no hard and fast rule, but there's a cost attached to it. But unless and until it's a breakthrough biscuits, which are very, very, very biscuits or cakes or anything. So these have become so generic. I think there's no involvement of any novel things which you can attract public now or people for getting.
Question by Mr. Mohan Rao Hanchate. Which type of remedies are preferred, whether common law or legal, civil law or legal law? That is, it is either infringement or passing off, which is preferred with respect to trademarks.
See, basically, if you're in the act says that if you're not registered your trademark, generally in a common law country, you can still get you are passing off, but you will not get your damages, but you will get an injunction. But if you are protected under by a trademark act and you're having a trademark, you can get the damages and also the losses which is there. So the best thing is get the trademark protected, because when you go into the court of law, the court will ask for a document or an evidence where a certified copy will speak volumes, rather than you taking out documents saying that I am the prior user, I have been adopting the trademark long time and all that. So definitely, as a legal thing in legal field, everybody knows. I think everything is uncertain except the cost. So you win a battle or lose a battle, you appeal, or so it's everything is related to cost, whether it's sending a legal notice or a thing. So you have to play your strategy very thing. See, Bawarchi has not gone for a enforcement, whereas Paradise has gone for an enforcement. Now you don't see any Metro, Grand, Silver, Paradise in the city. 17 injunctions were granted against Paradise for Paradise. So all Paradises were closed immediately because they filed a complaint in the High Court, and the case got injuncted immediately. And there was no damages given, but injunction was given. So because everybody were passing off by using a prefix or a trade suffix. Bawarchi didn't choose to go the enforcement way. So still you find high-tech Bawarchi, silver Bawarchi. So it's your choice. It's nothing to do with anything that you have to go for behind people. If you have the teeth and nail and the time, and you see that people have eaten into your business, it's high time that I should revolt and take out my armor from the armor, from my the sword from my the armory. Then I can definitely take it out anytime. So that's how it is.
We have a follow back to the explanation with respect to the patent and copyright. Sir, again Ravi Raghavan Kotla says copyright, it is only the expression which is protected, but not the idea. So ideally, I shall get copyright. Prior application is not made under the Copyright Act.
See, but the question is that, in copyright, what I'm saying is, if you're expressing it generally for ideas expressed in a copyright, it is for films and poems, and for software language, it is nothing to do with expression of copyrights for language. For languaging of the codes and all are very similar. So you will be you know what you're picking up and what you're writing. So suppose if you're doing a coding for payrolls, or you're doing a coding for PFs, or you're doing a coding for billing system, the language which you are using can be different. A coder can make languages short, can make coding short or coding long. So that the each and every coder will get his own copyright for it. It's not that if I have filed a copyright or a code software for making a payroll, I can do it in a much bigger way, I'll get a copyright for it. But the other one has done in a shorter way, giving the same things, but that also gives a copyright. So it is how you should place it into the copyright office, and it is up to you whether you want to strategize your thing. So the best thing is to first file a copyright for your software, and then you're working with your team, whatever it is, the hardware or the other additional which is going, can be looked at as a patent. But if that software per se cannot be used by the other one, because which you have already submitted to the copyright office, the other guy cannot use that same per se coding language or the coding codes which we use to do another hardware and get a patent of it. He might get a patent, but again, you will be liable. You can take an action saying that there is a copying done the software which has gone into is copied. So that's the reason you have to be agile and very effective, and it's all case to case. We cannot just tell something unless and until we go into the depth of the matter to what codes have been used, what language has been used, what are the two programming languages will be compared. There are experts to do that, and then only you can actually take a call.
Sir, what are the benefits of becoming a patent agent over a common man? Like, what is the advantage or benefit of becoming a patent
Even
agent?
patent agent is a common man only. Nobody is
Yes,
a special man.
like other than patent agent, like maybe the question is the
I have seen who are not patent agents, they are drafting, far better than patent agents. So if you ask me, I would say I will rate myself as a patent agent. Out of 10, I will give myself as 5 or 6. And people who are not patent agents, who are good in technology, are drafting wonderful patents and doing a lot of great work. So it is over time what people learn and become. So it is nothing to do with common man or thing, Kiran. But yes, patent agent gives you an advantage as a new career option. You will be picked up in various companies. And once you're a patent agent, you can, that link between technology and law will be more strong, the bonding. So that bonding will help you to carry forward once you're a technologist and then you have a patent background. So that will really take you to places, because techno-legal experts are in vogue today and much in demand. With evolving technologies, you need a technology professional, because technology and law are going hand in glove, but technology always outpaces law. So technology is ahead of law. So you should understand that the law will come after your technology is there, but law will be there to protect your technology also. So it's a very complicated answer which I have given, but yes, in one word, it is always better to learn about patents, study about patents, know about IP. But yes, if you want to take it as a career, patent agent is it's a very good feather in your cap, but not must or mandatory or 100% needed. You can do patent drafting, nothing stops you. You can do patent advisory. You can do a lot of things with your technical knowledge and a little knowledge of IP by studying the statutes, acts, and rules.
Thank you so much, sir, for the lecture on the designs and patents, and how it is useful to the academia and also other aspects. Yes, sir.
Thank you, Dr. Irfan. In fact, I must thank Mr. Subhajit Saha for, in fact, delivering such an excellent lecture. I have been with him for almost 80% of his lecture, but for the last few minutes. And I would like to inform the august audience that Mr. Subhajit Saha is recovering from COVID. And, in fact, even when he could come out of isolation, I contacted him and he readily agreed. So therefore, I extend my special thanks to Subhajit for coming to our rescue and for enlightening all the participants. And we hope to see you in many more programs, Mr. Subhajit. And we also thank all the participants for joining on this weekend lecture. So please continue to, in fact, encourage the DPIIT IPR-Chair of Osmania University in conducting many more programs of public interest, because we are trying to inculcate some kind of IPR culture in academic institutions. And today's lecture goes a long way in encouraging the potential inventors and innovators in commercially exploiting their intellectual property. Thank you all.
Thank you, DPIIT sir. It's always a pleasure to see you and listen to you. Thank you so much for giving me this opportunity. It's a pleasure. Thank you so much.
It's our pleasure. Our pleasure. Thank you. Thank you.